So we're listening to the opening statement of the prosecution. In this case, again, Roy Oliver, which he explained, but is accused of killing, he did kill, a high school freshman who was in a car when he opened fire. I'd like to introduce our guest, Ross Kramer. Always happy to see you. I get to have you a lot. Defense attorney here is our expert today.
Thanks for having me.
Absolutely. So let's talk about Van Dyke. First of all, we talked about earlier, and that is the one where the officer on duty shot and killed McDonald after, I believe, 16 shots. The prosecution just said in opening, in this time, the officer fired 12 shots into the car and killed the high school freshman. Is there any inference that, hey, that many shots is overkill, and that honestly, if they've shot that many times, it was not reasonable?
Well, absolutely. I mean, the first inquiry is always, was the use of deadly force reasonable in the first instance? Was the first shot reasonable? And that's really the core inquiry in these. It was Van Dyke when you saw Laquan McDonald walking away and that first shot was fired before he hits the ground. It's here where a car was driving. It's really the inquiry as, should that officer have taken that first step? But I think the next 15 shots in Van Dyke or the next 11 shots here really add a lot of color to whether this officer was in control of the situation, really had thought through what was happening, and whether he was acting appropriately.
So we've discussed that it's rare across the nation that police officers who kill in the line of duty are actually tried on criminal charges. Here today we're discussing these two cases, and Roy Davis was on duty when he shot this freshman in high school. So my question, Ross, is do you think that there's an increase in these number of charges and trials against officers who shoot in the line of duty because of public hearing about it, knowing about it, and it's just finally coming out and they're finally being tried?
I think that's part of it. I think the public activism is definitely part of it. But I think that the technology that's there is a bigger part of providing the evidence that allows these cases to go forward. Having body cams on officers, having citizens with cell phones and able to take video of incidents, having them able to record audio and actually see what happened at the time is such powerful evidence to look at a police officer's actions and determine whether they were reasonable at the time. That didn't exist 20 years ago. In the OJ case, that was, a new technology that somebody happened to film things. In cases, throughout the country, there were some video in places, but now it's really starting to get so popular throughout the country. I think there are going to be more and more of these prosecutions.
All right, so we're going to see what happens in this case. Again, we started off by showing you the body cam video. Now we're going to return to more of the prosecution's argument to see what exactly are they saying they're going to prove in this case.
You'll hear evidence that all 5 of these shots, all of them, including the first one, were fired after the Chevrolet Impala had already cleared past Tyler Gross. No danger whatsoever, none. But the murdering spree continued. Even after the car passes the defendant as well, who was situated just a little bit to the south of Officer Gross, he continues to fire. He turns on a 45-degree angle to the southeast and fires 3 more rounds. There will be evidence of all of that, and you'll see. Again, all 5 rounds fired after that car has passed Officer Gross. No danger. No reasonable police officer, you'll hear testimony, would have engaged that car. No way. The kid's now panicked. The doll figures out fairly quickly that George has been hit. The sadness begins to set in, and the panic, the fear. They drive 2 roads over to Bishop Lane. They make a right going back to the west. They don't know what to do. They're teenagers. They're kids. Meanwhile, Officer Jeremy Chandler, acting very honorably that night, I might add, deploys over to Bishop. He's heard the first call of shots fired. He thinks that he has to do a felony stop because he doesn't know what exactly has transpired up by the nursing home. You're going to hear evidence that those 12 shots were fired by a man named Tupac. That's his street name. His real name is DeMichael Rose. And I'm going to tell you how you're going to hear that in a moment. You're also going to hear that all 12 of those shots were fired after the 5 kids were already in the car, so that none of them could possibly have been involved in any of that.
Well, there you heard it from the prosecutor. Roy Oliver shot into a car, firing 12 times. There were other teenagers in the car, but he did kill a 15-year-old freshman, Jordan Edwards. Now, you are not going to want to miss the next testimony that we're going to share with you. That is going to be testimony from the other youth who were in the car with Edwards when he was shot and killed. Stay with us. We'll be back right after this short break. Now, there was someone else in the car, and we're going to hear from this young gentleman as well. Remember, these are all kids for all intents and purposes, 18 and younger. So they're all in this car with this freshman in high school who gets shot. Let's see what another individual in the car, and it's Maxwell Everett. What did he see?
So then we stayed there, but like we turned like back facing the road that we came from, like the main road. Yes, sir, like that road. We turned facing that road, and then that was when the cop came back down the road to coming down.
Did y'all wave that police car over?
Yes, sir.
Why'd you do that?
Because like we knew on Jordan needed help.
You knew Jordan needed help.
Yes, sir.
What happened then?
Then the cop had stopped behind us, and then Vita was telling him like Jordan was like hurt.
Let's call him a police officer, not a cop, okay?
Yes, sir.
All right.
And then he was telling the police officer that Jordan was hurt. And then he was like, okay, like, we're going to get help for y'all. And then,
When you say he was like, you the police officer that's down there?
Yes, sir.
Did he tell you to stick your hands out of the car?
Yes, sir.
Did you do that?
Yes, sir.
Eventually, did you get pulled out of that car?
Yes, sir.
You did that on your own volition?
Yes, sir.
Okay. Were you the first or the second person to come out of the car?
Second, I believe. Second.
After the driver?
Yes, sir.
And what were the instructions that were given to you?
Walk backwards with your hands up.
And so did you do that?
Yes, sir.
And were you placed on your knees?
Yes, sir.
Handcuffed?
Yes, sir.
Now, you were behind the dial alley, correct?
Yes, sir.
Okay, so your view of the officers and the shots would have been obscured by Kavan and by Maximus, right?
Yes, sir.
Okay, so you didn't have that good of a view of the whole thing?
Yeah, no, sir. I have to.
Figured out that Jordan had been shot. How'd that make you feel?
I was shocked. Like I ain't know. Like at first, like since he had like bought that red drink from the store, I had thought that he spilled his drink, but like it wasn't. He ain't spilled his drink. Like that's what I really thought. Like for real. So then once I seen that, like.
Are you going to be able to keep going, son? Okay. Jordan was a good friend of yours, wasn't he? Max? Right?
Yes, sir.
Were you in fear of your life when those shots were fired, Maxwell? Can you answer my question, Maxwell?
Yes, sir. I was.
That's certainly some of the most compelling testimony that we've seen. He was in the back seat. He saw his 15-year-old friend get shot, and he just testified, hey, I thought he'd spilled his drink all over him. It was red, only to realize that he'd been shot. Ross, let's talk about the witnesses so far and the state's efforts to really set the stage and tell the story. Do you think it's effective that they've started with the witnesses first to say this is exactly what we think happened before they go into any, if they're experts or not, or any other testimony?
No, I mean, this is absolutely the way that the prosecution should put this on. It's the classic way they do it. They want to show what happened before having, the real conversation about why it was wrongful and what the problem was and the legal issues here. But this testimony is so emotional with these young people who are actually there. Even the collateral damage here, people who are in the car, it's going to be very hard for them to recover from this kind of thing. And showing them and how emotional the scene was before they get into the legal issues, I think is exactly right.
And so let's talk a little bit more about that, the kids that were in the car. And are they going to be traumatized forever, in your opinion?
Forever. I mean, the lawyers who work on this case, a judge, jurors who have to see pictures in these cases, there's so much collateral damage. The families of everyone who has to participate in this. The victim, obviously, is the primary victim in a case like this, but there's so many victims.
All right. So we are going to see the officer who was wearing the body cam, what he had to say about it after this very short break. Please come right back.
And then you reach the car and tell the ladies and gentlemen of the jury where you were when you finally got to the car.
Do you want me to skip the part where it turned, or do you want me to just start back where I was at?
Yes.
Okay, so then I read the license plate twice. On the second iteration of reading the license plate, I realized the vehicle was attempting to evade instead of just backing up. I then began telling him to stop the car, and at that point I walked up. The vehicle had backed up and then backed north on Shepherd. So from eastbound Barron to northbound Shepherd, as it backed up like this, I stepped up onto Shepherd Road ahead of the vehicle, and the vehicle then stopped briefly. I thought it was going to stop. I continued towards the vehicle, then accelerated forward, driving past. I then reached out and I hit the vehicle, which broke the rear passenger window. Immediately after that, I heard a series of gunshots as the vehicle then traveled down south on Shepherd. I then turned and saw that Oliver was standing next to me, and I saw the smoke from his weapon.
What did you conclude from the smoke coming from his weapon?
That he was the one that had shot.
Did you ever feel like that Fidel Allen, the driver of that car, was trying to drive over you or hit you?
I didn't. I was not in fear at that point.
All right, Officer Gross. Ross, let me ask you about his testimony. So he described what happened. He said that he did hear shots. The vehicle was attempting to elude him and flee. He heard shots. It was Officer Oliver who shot from behind him. What's the import of testimony that he perceived the car to be fleeing or evading?
Well, I mean, I think it's very important and very credible testimony here when he doesn't make any effort to exaggerate the facts, to make it sound like he believed he was in danger or his partner was in danger or any pedestrians or bystanders were in danger. He seemed like he was really in control of this situation, was observing it, didn't feel like there was an immediate danger which justified deadly force here. And I think his testimony is very, very important in this case.
All right, so you mentioned on a break in Van Dyke, quickly, the conspiracy charges allege that they've covered up a crime. Do you think in this case, based on his testimony, that he was trying to cover anything up, or did he say, hey, this is what I saw?
Well, he reminds me of some of the other officers who testified in the Van Dyke case credibly about the fact that they were on scene, they didn't need to fire any shots, and they don't really understand, by extension, why their partner did.
All right, so it's going to be interesting to see what happens in this trial. We will take a short break, but you will not want to miss, again, testimony we're going to show you here on Law and Crime, because you are going to see not only the cross-examination of Officer Gross, but remember, today is the defendant speaks. So guess what? Yes, we are going to hear directly from Roy Oliver as to his perception at the time.
Recall, he could have hit me, and I wasn't in fear so much as that I shot, but I was in fear.
I was in fear the vehicle was close to me. I didn't think the vehicle was trying to run me over.
And when we look at this, one has to look at the perception of being charged in the crime. You didn't get charged with anything, correct?
That's correct.
Though you were read, basically, they're warnings for a suspect, but they're the Miranda warnings. You got a grand jury. Did your vantage point, you would agree with me, is different than Officer Oliver's.
Yes.
You were close enough to the vehicle that you're closer than a yardstick away from the vehicle at the time you break the glass.
Yes.
And while I think your testimony at the grand jury and with Detective Carranza and your statement that you've written is that simultaneously to the glass breaking, Officer Oliver discharged his weapon.
Yes.
So if that's a simultaneous event, then you're still near the vehicle or alongside of it, correct?
Yes. I was. It was moving fast as soon as it took off forward. It was fast and slow, and then it took off fast, accelerated fast. So immediately after the window broke, I was probably at least at the rear tail lights towards the end of the trunk, but not past me all the way.
So in cross-examination, the defense attorney, I think, is really grilling him about exactly where were you, what were you doing. What do you think defense is trying to get out of this witness?
Well, I think they're scoring some points here. They're showing that everything was happening very quickly, that this officer was close to the car, that the car was moving fast, the kind of things that would make the officer who did the shooting perceive that there was a danger and that he had to act. We saw in the previous witness one of the kids in the car who said everything happened within a second. This was a split-second decision that happened. Everything was jumbled. Everything happens very fast. And that's really the only defense that these officers have in this kind of case. It's sort of that fog of war defense that everything was happening so quickly, I perceived danger and I acted on it. If I would have waited, I was worried that this would have ended up in another officer's death.
All right, so is it fair to say they're going to have a heightened sense of urgency when you have this much chaos and you've heard gunshots and you see cars and you have a lot of kids piling out? Is that going to increase their heightened awareness and make it that it justifies more use of force? That it's reasonable in their minds even if it's not?
Well, look, I don't think it was objectively reasonable here. I don't think anyone really looking at this might think it's objectively reasonable, but I think it's attempting to set up the subjective reasonableness. And that means that not looking at what an average police officer would have done here, but this police officer and his perceptions. And when everything was happening very fast and when there's a car screeching towards his partner, what he thought and what he perceived.
All right, so it's going to be interesting to see what happens with this case, but we're going to hear a little bit more of the cross-examination of Officer Gross.
Officer Gross, can you take us through the elements of evading with a vehicle?
Whenever a vehicle, have you attempted to stop a vehicle for any reason, and it attempts to evade you? By evade, we mean try to lose you or get away from you. We have two different types of things you can do if you don't stop immediately. It's either evading, where they're trying to lose you, or elude you while they're just trying to drive back to their house. So their car will get towed because they're whatever reason they have.
All right, well, one of those elements, and Officer Oliver standing trial here for a murder case and 2 aggravated assaults based on the color of his employment, that he was a peace officer. Part of the elements for evading arrest is disobeying a lawful command of somebody such as yourself as a peace officer. Is that correct?
That's correct.
So based on your duty of your employment as a peace officer, not following that command sets up the elements for what you just talked about. Is that correct?
That's correct.
Can a vehicle be a deadly weapon toward a pedestrian standing outside?
Yes.
I have to tell you, watching Officer Gross, Ross, to me, he looks like he's just about to cry and really uncomfortable. What do you think?
I agree. I mean, I think it's very hard to testify against a partner in law enforcement. And I also think, like we talked about before, this is one of these cases where there's so much collateral damage to the community. This person who watched this happen to a group of kids is never going to be the same, either personally or professionally, after this case.
So now we've heard from all the prosecution's witnesses, and in a defense attorney's mind, I assume you're starting to think about, do we have the defendant testify or not? How do you make that decision? That's a tough decision.
It's an extremely tough decision. So you're starting to think about that before the case, because you have to have this defendant prepared in the eventuality that he's going to take the stand. This is completely his decision, counseled by an attorney, but it's one of the few decisions in a trial that the defendant gets to make. Traditionally, the thinking is that you don't have a defendant testify unless you're way behind, because it shifts the burden to a he said, she said, who do you believe? In the American criminal justice system, it's purely the prosecution's burden to prove their case beyond a reasonable doubt, which is the highest possible burden. Once you put your own witness on the stand, all of a sudden you're putting his credibility at issue, and you're giving the jury the perception that maybe you're trying to prove that he didn't do something wrong, as opposed to the prosecution having to prove that he did do something wrong.
Okay, but what about this? Just devil's advocate. A lot of people say, hey, if a defendant doesn't testify, they must be hiding something, so they're certainly guilty if they didn't testify. Does the jury consider that?
You know, a jury is not supposed to consider that. In a voir dire, when the jury is questioned originally, a judge will give them that instruction, can you follow all my instructions on the law? Throughout the trial, at the end of the trial, and as part of the instructions, a judge will remind over and over again that a defendant has no obligation to testify, and you cannot draw any negative inference, you can't draw any conclusion from the fact that he's exercising his constitutional right not to testify.
Have you ever briefly had a case where you have advised your defendant client, I don't advise you to testify, and they've said, too bad, Mr. Kramer, I'm testifying?
I haven't, and that's because generally people don't want to testify. And usually it'll take an attorney to talk them into it if they believe that it's necessary, but that's a rare occurrence.
All right, that is some excellent insight from our expert analyst, because I've always wondered, hey, what if a defendant says, I'm doing it anyways? So that may not be the norm. We are going to stay on this trial, and again, Defendant Speaks Day. Come back so you can hear firsthand what Roy Oliver says happened in his mind in this case. We'll be right back. Thank you, Anthony. You find the greatest stories nationwide. What about $200,000 in cash coming out of the back of an armed truck? Of course people are going to stop and pick it up, which is what they did. They faced charges if located. Now, on that note, we are going to return to the trial of Texas versus Roy Oliver, and we are going to watch again the video from the body cam of one of the officers.
Hey, Hamburger, come here. Have a seat. Where are you at school?
West Mesquite.
All these West Mesquite kids? Maybe?
Wow, some of them Mesquite, pretty much all the same.
Listen, don't do this again.
Yeah, this is a one-time thing, sir.
Mr. Rhodes, I'm Officer Gross, okay?
Officer Rose.
I don't want to see this again.
Yeah, let me go see this again. I ain't expected to get this
I know.
type.
Hey, stop that car! Stop right there! Stop!
1661 code 2312 64 62 Just him around somewhere in the center area.
Stop! Copy 28. Charles Sam 7 Young 882. Charles Sam 7 Young 882. Hey, stop that fucking car! Stop that fucking car right now! That fucking car! You alright? Yeah, I'm fine. He was trying to hit you. Stop! Stop!
All right, so it's very chaotic, and the video is not the best quality, but here's what we know. You heard him say, this is Officer Gross, he was at a party, and he was telling him respectfully, in my opinion, hey, I don't want to have to come here again, I don't want to hear this. as he's doing that, you can hear something that sounds pop, 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 like shots in the background. He takes off outside, and you see a car backing away, and he's yelling, "Stop the car, stop the car." Ross, are you able, when you watch the video, to tell exactly where the shots were fired or when, once he was yelling at the car to stop?
No, I don't think you can see that level of detail here, but I don't think that's necessarily what's important here. I think this is a lot like the Van Dyke video, when you can see that things appear basically in control for the officers here, that they don't appear panicked, at least most of the officers, except the one who shot, don't appear panicked, don't appear to believe this is a life or death situation where either an officer's life or a bystander's life is in danger, and one officer out of a group decides to use deadly force. They really parallel each other, in my opinion.
All right, but what about the fact that it seems to be very chaotic? You see lots of people in the house, he comes running out, there are a lot of cars, a lot of police, a lot of activity. All of that's got to make a difference to a police officer who's there and trying to protect others and themselves.
I think a lot of the chaos on this particular video may come from the fact that the officer was running, so the body cam looks like it's bouncing up and down. I don't think that in this video, it doesn't appear like a car is approaching this officer. It doesn't seem like anybody's going to get hit by a car. You don't see any guns. You don't hear anybody yelling that they have a gun. I don't see that this video helps the defense very much at all.
Okay, and that's what I think is significant, is you don't, like Ross just pointed out, you do not see a car backing up or driving towards Officer Gross. Now that we know and the stage has been set as to what happened, what is Roy Oliver going to say happened in his mind? Well, now we're going to hear directly from him in his testimony.
Situation, you assess it for one, what it is, and two, for what it might be. In other words, it could be a dangerous situation.
Yes.
Was there anything about those young adults and you going in that house that gave you the feeling that this was a dangerous situation?
No, not at all.
But were you amazed the number of people were coming out of that place?
I was very amazed by that.
Did you follow Gross into the house?
After a second or two, after he'd made entry into the house, and I stayed outside to where I was close enough to hear if he started yelling, but I was outside to where I watched the partygoers disperse. They weren't causing any issues. They were dispersing. No need to stay out there. Went there to be closer to Officer Gross.
Well, what was your job while you were in the house?
I just did a quick officer safety check of the house, make sure no one was hiding, make sure there's no alcohol since it was alleged, any intoxicated juveniles, make sure no alcohol that was hidden, thrown in corners, someone that was intoxicated to where they passed out and needed medical aid. I was just doing a quick look around.
What happened next?
After I conducted a quick little look around, checked the backyard, and got next to Gross, then we heard gunshots.
Well, you heard. What did you think you heard?
Gunshots.
And you've heard plenty of gunshots, haven't you?
Yes.
You've heard plenty of semi-automatic weapons being fired.
Yes, sir, I have.
So what was your impression as to what?
This is the defendant, Roy Oliver, telling what he was doing, how many people he was amazed to see in the house, going through a quick walkthrough of the house. Now let's see his description when he heard shots.
The training that you had?
Yes, it was.
Did you have a sling on the weapon in right?
Yes, I did.
Okay, what happened next?
I am walking basically the same path that Gross has taken. I've got the rifle slung, or I'm about to sling it, and then he gets on the radio, and I know Gross. I've worked Gross many years. He gets on the radio, call out a license plate. You do that. I know you do that because you want dispatch to know what car you are trying to stop, have suspicions about. There's some reason you want that license plate. Of all the cars he's passed, he hasn't called out any license plates. He calls out this one. His tone of voice is not the Officer Gross that I'm familiar with. His pitch goes up.
Did you hear him tell that first vehicle to stop where you are?
I heard him yelling and giving commands. I couldn't tell exactly what he was saying, but I had a general idea.
Or did you see that vehicle stop and follow his command?
Yes, I had to walk around that vehicle.
Were the people in that car?
Yes, there were.
Did they move?
They did not.
Because they were told to stop and stay right where they are?
Correct.
Then what happened next?
I look up to see exactly where he is at now, and he is focused on one vehicle, and he is walking at a decent pace. He's not running. He's not walking. He is walking at a good, decent pace towards this car, yelling at the top of his lungs, adding, I think, what we've determined as salty language at this point.
That's pretty typical.
In high-stress situations, that has a tendency to come out.
Did you think at that point that Gross was, his perception was this was a high-stress, dangerous situation?
By the tone of voice he used on the radio calling out the license plate, and by using the salty language, that told me this is a very, he's seen something, not sure what it is, but he is locked onto this car, and my hearing and my eyesight is telling me he's intent on this car. There's something going on with this car, and I've got to get out there to help him with it.
Well, would it be fair to say that you were basically following his lead?
Yes, he was setting and dictating the pace on everything. I'm just there to support him on whatever it is he needs.
Why did you start to run, as we saw in the video?
Because his voice had changed on the radio, the high pitch that told me he had something that was making his body react in a way that he was not comfortable. So I needed to get up to him really fast.
All right. Let's call a spade a spade. So he testifies Officer Gross was using salty language. That would be stop the effing car, which he'd already heard testimony about. He also testifies that he thought Gross's perception was, we got to lock down. He'd locked onto this car, and he could tell that because of his voice on the radio as well as his language. Ross, what do you think of that? Is he credible? So what?
I think it's not about credibility here. It is about the so what. There's nothing that he said in his testimony so far that a defense lawyer couldn't have argued without this testimony. A defense lawyer could have said, listen to that tape. You hear his voice change. You hear the pitch of it. Take this back into the jury room. Watch the tape for yourselves. You didn't need this testimony so far, and I think a big negative from this testimony was when he said his partner was walking towards the car, not running away from the car, not diving out of the way, walking towards the car. And his calm demeanor in his testimony, I don't think helps this either. So far, I haven't seen the value in this testimony.
All right. So you will not want to miss. We're going to come back after a short break, and at that time, you will hear him testify as to why he shot and killed this 15-year-old victim. Stay tuned. Well, there is Mr. Oliver, the defendant, describing in great detail what he recalls he saw. And he even states the car was accelerating forward. He was afraid it was going to hit his partner, that the car is a deadly weapon. And let's see what he did next.
Hayden said it was 9 seconds up to where the shooting actually occurred, and then the shooting decisions and all was that fast. Can you clap your hands as fast as they're talking about?
No, I cannot.
Are you surprised at Dr. Hayden and all these reports as to how quickly an officer has to make that decision?
They're very surprising.
Did you ever go through Force Science and study all of this and everything?
No, we get a brief couple hours on it in the police academy about action reaction, how to cut that down to save our lives, but we don't get into the science.
Well, when do you think you made the decision to fire that weapon?
When the vehicle was moving towards my partner.
Did you hear something happen when the vehicle was moving towards your partner?
I heard some type of possible gunshot from inside the car, but that was after the thing was coming to my partner.
Well, it all happened that fast, but was that a factor that you put into the computer to tell your brain that you got a dangerous situation?
Possibly. I had a lot of information to process real fast, and I almost watched my partner get hit by a car.
When you made that decision, when you made the decision to act, were you trying to stop a vehicle?
I was trying to stop threats towards my partner, towards anyone out there.
Well, did you intentionally shoot into that vehicle?
Yes.
Well, let me ask you something, Roy. We're going to talk more about down because they've shown all these videos. But after you fired those 5 shots, do you agree with Dr. Hayden and all these other pros that came here and said we good shot him with the rocket panel or the concrete first?
I really can't. I mean, there's a possibility that it could.
But after your decision was to stop shooting, what do you do with the weapon at that point?
After you've completed the interval, whatever you're doing, the rifle with your thumb places it on safe, and you lower the barrel to a lower position.
Well, what was your immediate thoughts after you fired the weapon?
Make sure my partner was okay.
What did you say to him? Do you remember? What did you think that just happened?
I thought he was about to get run over or at least gotten clipped by the car at bare minimum.
I think the tape says you said, "Are you all right?"
I know I checked on him. I just don't remember my exact wording. I want to make sure he was okay.
All right, so the defendant just testified, hey, everything was happening very quickly. There was not a lot of time, a lot of information to process. No doubt, especially given the testimony of all the other witnesses and the chaos that was ensuing. But Russ, how does that possibly justify any officer shooting into a car to remove what they perceive as a threat?
I don't think it does. I don't think that shooting into a car is going to remove the threat that they saw here. When you have, like in the Van Dyke case, somebody with a knife, or another case, somebody with a gun, and you want to disable that person by using deadly force, you can see logically how an officer discharging his weapon can remove that threat. When you have a car with somebody with their foot on the gas that may or may not be aimed towards your partner, I don't see how firing shots that could only make the scene more chaotic, that could only risk somebody taking an action they might not have otherwise taken, would remove the threat to the officer's safety here. It just seems like all around this doesn't make any sense. There's not a real coherent, thought-out defense here.
Okay. You mentioned something on break, and that is the way that he's telling his story. As a defense attorney, is there any more effective way that you could think of he could tell what he saw?
Well, look, he's trying to tell an honest story about a chaotic situation, a life and death situation. You would think that he'd be coached about how to tell his story. His story is his words. But he had to get on the stand and say, you know, with some emotion, this was all happening very fast. I saw a car racing towards my partner. I saw immediate danger. I saw death for my partner in the future if I didn't take action. He's talking like he's on a coffee run here.
All right, so what is cross-examination of Roy Oliver going to be like, given the fact his testimony was kind of like, hey, here it is, not very compelling or exciting to listen to? We're going to see right after this short break. Please come back and join us. Welcome back to Law and Crime, where we cover trials nationwide, gavel to gavel. Now, Roy Oliver in Texas is being tried, but one of the things we always have to keep in mind and remember, whether or not a jury finds that the force he used as a police officer was reasonable or not, we still have a 15-year-old child in this case that was shot and killed, Jordan Edwards. So certainly think of the family in terms of the loss to that family and the trauma to those who witnessed this horrible event. Having said that, now we're going to see what the cross-examination of the defendant is like after he's told his version of what happened.
Shooting warning shots that night?
No, that's prohibited and it's not safe.
Were you trying to shoot the tires or the engine to disable the vehicle?
No.
Okay. And that's because you're not allowed to do that either.
Correct.
Okay. Were you trying to seriously injure or kill the driver of that car?
I was trying to stop the threat inside the vehicle, correct?
Were you trying to kill or seriously injure the driver of that car would not allow him.
That was one of the threats, yes.
Okay, so yes is the answer to that?
Correct.
Okay. I mean, because there's no other reason to be pouring 5 shots into a car, is there?
I was not aware that it was 4 or 5 shots at that time.
Okay. You admit that you fired 5 times.
I was told that I did, correct.
And you know that the only time that you can conceivably shoot into a moving vehicle like that is if you're trying to use deadly force against the driver of the vehicle.
If it's being used in a deadly force situation.
So is that what you were trying to do?
Stop the threat, yes, sir.
Okay. Do you know all of the problems, reasons why you don't shoot moving cars?
All of them? I don't think there's a way to know all of them.
Okay. Isn't it correct that you don't shoot at a moving car because you're wasting time and you could be getting out of the way?
Correct. I could be getting out of the way.
Isn't it true that it's very difficult to shoot the driver in a moving car?
That's a true statement.
Well, that sure seems to be a pretty effective cross-examination. So, Ross, I don't understand. His testimony is, we're not supposed to shoot at the tires. We're not supposed to shoot at the engines. I'm trying to stop the threat. I'm trying to stop the threat. So it's okay to shoot into a car to stop a threat?
I don't think so. This defense lawyer doesn't think so. I'm sure the prosecution's expert testified that it's not acceptable. His distinction seems to be that he was using a high-powered rifle to do it, and it would have a better chance of neutralizing the threat. It doesn't seem to me he even knew who were the occupants of that car, what was happening. This is not testimony that seems to me it's going to convince a jury that he was acting appropriately. I haven't seen anything yet in his testimony that would lead me in that direction.
And he didn't even say, when he was questioned more than once, were you trying to shoot the driver of the car to stop the threat? He couldn't even say, yes, I was aiming at the driver, that was my intent. He couldn't say.
Yeah, some of this is on his attorneys, honestly, because you have to be prepared. These are the questions that anybody's obviously going to ask. What were you trying to accomplish? Who were you aiming at? What were you shooting at? How were you trying to comply with this policy that you should have known about? It almost seems like he's thinking of these things for the first time when he's hearing the questions.
All right. So Ross just mentioned the use of threat and if it's reasonable or not. How do we know if it is or not? By experts, of course. So the prosecution presented its use of force expert, and we're going to share some of that testimony.
That using deadly force was reasonable under the circumstances.
I did.
And what was that opinion?
My opinion that a reasonable officer would not have done that. And my reason for that is because as they were approaching, there's about a 9-second point from where Officer Oliver retrieves his rifle to the point he gets to the shot is fired. During that point in time, it has been mentioned that the eye is better than the video, that you can see more. And I would agree with that. You can. As he's running, or both of them are walking at the time, and coming up in this 9 seconds, there's a lot of time that Officer Oliver has to look over at Officer Gross and see what he's doing. He can see well, he can see Officer Gross approaching this vehicle. Officer Gross is walking towards this vehicle. The vehicle's not coming towards him, he's walking towards the vehicle. At that point in time, he starts to pick up his pace, and he ends up getting to the vehicle about the same time, or getting close to the vehicle about the same time that Officer Gross gets to the back window, and the back window is broken. A fraction of a second is when Officer Gross is by that window. Now, with Officer Oliver coming up on that at that time, he had plenty of time to see that Officer Gross was not in danger, that Officer Gross was a distance from the car, from the back wheel, and he was walking towards that. So he had plenty of time to understand he's not in danger. As he's coming up on that vehicle, what happens at that point in time, he doesn't look, or he does look, and I don't know what he says he's doing at that point in time. What we saw in the video is that if he would have done that and come back on what he was looking at on target, I'd say, is that that vehicle would have been past him. The vehicle would have never been in front of him. So there's no way at that point in time when the window was broken that he could say, I looked over and saw that he was in danger and then looked back and engaged the target. Not enough time to do that. So that's why I'm saying that there was no threat to Officer Gross at any time. He says so. And I don't see anything in the videos that show it to be a threat. So I don't believe that Officer Oliver would have seen it as a threat. So he shot at that point in time. That's why I say it was excessive force. It was not necessary because no crime had been committed that would have brought that deadly force to bear. Because deadly force is only used if you have to defend yourself, defend another, and you have to look at this thing. It's a terrible thing you have to use. But if you have to use it, you better use it, and you better use it right.
So the state's witness says, listen, a reasonable person would not have used this force, and there was plenty of time for him to have seen he was not in danger. Let's talk strategy. What does defense do about this kind of testimony other than cross-examine? Anything they can present?
I think that they have to put on their own witness at that point. An expert witness carries a lot of weight in a trial. It's presented to a jury as this is somebody who has knowledge beyond your own understanding, who will explain to you these difficult concepts, and not only that, but will render an ultimate opinion on what they believe happened here. Having one side put that on and not the other side is a big imbalance. So I think that the way to counter that here is to have an expert for the other side who will say, this was justified. I've watched the same video. I've seen the same testimony. I think this was appropriate.
All right, so we have saved the best for last. We'd have to take a short break, but when we come back, what is the verdict in this case when you heard directly from Roy Oliver, and what happens next? Stay tuned. Does a jury convict Roy Oliver? Let's watch and listen to the verdict.
Verdict forms to the bailiff. Is that correct? Yes, sir. I have those. Mr. Gill, Mr. Oliver, Mr. Brissett, Mr. Lane, if you would please rise for the reading of the verdict. This is cause number F1718595-V, the state of Texas versus Roy Oliver. The verdict form reads as follows. We, the jury, unanimously find the defendant guilty of murder as charged in the indictment. Signed by the presiding juror. Mr. Janacek, is that your signature?
Yes, sir.
Members of the jury, if that is your individual verdict, if you would please signify so by raising your right hand. Please let the record reflect that all 12 members of the jury did raise their right hand. Cause number F1700576-V and F1700579. Verdict forms read as follows. F1700576. We, the jury, unanimously find the defendant not guilty. There's a signature here. Mr. Janacek, is that your signature?
Yes, sir.
And does that signify your unanimous verdict?
Yes, sir.
Members of the jury, if that is your individual verdict, would you please signify so by raising your right hand? Let the record reflect that all 12 members of the jury raised their hand. F1700579. We, the jury, unanimously find the defendant not guilty. There's a spot here where it appears that you have your signature, Mr. Janacek.
Yes, sir.
And there's also a spot where a part of it is scratched out, but you've written a note at the bottom. We, the jury, unanimously find the defendant not guilty, and that's your signature too. Is that right?
Yes, sir.
Members of the jury, if that's your individual verdict, would you please signify so by raising your right hand? Please let the record reflect that all... I'm sorry. Thank you. Please let the record reflect that all 12 members of the jury did in fact raise their right hand. Mr. Oliver, Mr. Gill, Mr. Brissett, Mr. Lane, you all may be seated. It's customary in our law and our procedure to take a break at this point, so if you would please go back with the sheriffs and await further instructions. All rise for the jury.
So there we have it. The jury did convict Roy of murder. The other charges, they found him not guilty. Ross, are you surprised or not surprised?
Not surprised with the guilty verdict on the top count. We're seeing more and more of these cases. We're seeing that with a body cam, with officers willing to testify against a fellow officer, with bystanders seeing the same thing and witnesses willing to come forward and testify, we're seeing a lot of these cases end up in guilty verdicts.
All right, so it is not the norm nationwide that these officers are charged and then convicted, but it has happened here. Justice for Jordan Edwards. Part of the thing that we have to think about in terms of justice is the sentence. Now that he's been convicted, what will he be sentenced to? Now, in Texas, the jury will determine the sentence. So what we are going to do is turn to what the sentence was in this case. What did the jury decide after convicting him of murder? Let's listen.
With Roy gone, is it going to be difficult for you to carry forward the Hobbs therapy?
Sí, porque Roy yéndose de tu casa va a ser difícil para ti poder cumplir con esto. Sí, porque yes, because of this. Porque la aseguranza cubre una parte. The insurance that he has covers partial. Y Roy pagaba el resto. And Roy would finish paying the balance. Era un pago cada semana. It was a weekly payment. Yo sé, porque también tengo hijos.
Are you asking this jury to be lenient on Roy?
Le pide a ellos que sean quebrantados hacia Roy. Que tengan misericordia. Yes. Él es un buen hombre. He is a very good man. Un buen servidor. Siempre le gusta. Good servant. He enjoys doing su trabajo. His job. Siempre listo para su trabajo. Ayudar a la gente. Was to help other people.
Are you asking the jury?
So before we actually reach what the sentence was, that was one of the witnesses in the sentencing before the jury. That was Ingrid, Roy Oliver's wife. And you can see she's emotionally devastated. She says he's a good man, he's a good husband. They have an autistic child who's young that she now has to raise on her own. Ross, are these mitigating factors in your mind that are going to help a jury say, okay, he shouldn't be sentenced as long as otherwise?
Yeah, absolutely. I mean, these are the kind of things where a jury is not supposed to be just deciding on what happened, but also looking at who the person is, the nature and circumstances of the offense, and also the characteristics of the individual. I don't like this procedure personally, where a judge is not making this decision and it goes to a jury. I think a judge has a much wider view of what's necessary to make it consistent with other sentences, with other conduct. He has a better view of deterrence and rehabilitation and a lot of other issues that I think a jury who has no experience with criminal law has. But in this case, I think this is probably very powerful testimony for a jury to consider to mitigate a sentence.
And interesting, I just want to note that they even asked her, do you understand that a young man has died in this case, that he shot and killed a 15-year-old? And she says, yes, I do. So I just think it brings home, you know, she's a victim too because of her husband's actions that led to a some would argue, very just conviction. She now is raising her own child without him because he will be serving time. How much time? Let's return to the sentencing hearing to see what the jury decided in this case.
Guilt, Mr. Brissett, Mr. Oliver, Mr. Lane, Mr. Thompson, if you would please rise. The verdict form reads as follows. Cause number F1718595, the State of Texas versus Roy Oliver, in the 292nd Judicial District Court here in Dallas County, Texas. We, the jury, having found the defendant Roy Oliver guilty of murder and having made a negative finding on the special issue of sudden passion, assess the defendant's punishment at imprisonment in the institutional division of the Texas Department of Criminal Justice for a term of 15 years and a fine of $10,000. Mr. Janacek, members of the jury, if that is your individual verdict, would you please signify so by raising your right hand? Please let the record reflect that all 12 members of the jury did, in fact, raise their right hand. Mr. Gill, is there any lawful reason why your client should not now be formally sentenced?
No, not.
Very good. Roy Oliver, the jury having found you guilty, and the court has accepted your guilty finding, has accepted the finding of guilt by the jury unanimously as charged in the indictment for the offense of murder. It's now the order, judgment, and decree of this court that you be taken by the sheriff of Dallas County and by her safely held until you're turned over to an authorized receiving agent for the Texas Department of Criminal Justice Institutional Division, wherein you shall be confined for a period of 15 years and assessed a fine of $10,000. That sentence will begin today, but you will be given credit for all of your back time in this case. You may have a seat.
So the jury's sentence, 15 years and a $10,000 fine. The judge accepted that. Ross, is that justice for this victim? 15 years on a charge of murder that was a conviction?
It's hard to look at it that way. There's no justice for this victim. There's no bringing him back. There's nothing that's ever going to really help this family. I mean, I think you have to look at this holistically. I think 15 years is a pretty lenient sentence, and what it probably reflects is that the jury was convinced that this was a generally good person, and it may have been a responsible police officer, but in this one instance acted so far outside the bounds of what society is willing to accept.
All right, and so what's next? Do you envision an appeal? How do you know as a defense attorney, if you're watching this, if you think there are good grounds to appeal or not? What's your opinion?
Yeah, I mean, there could be legal issues. I'm sure there'll be an appeal. It's almost automatic in these cases to explore what legal issues there were, the weight of the evidence that allowed the verdict. I don't know what pretrial motions may have been present here about what testimony was allowed, what testimony was not allowed. Sometimes if a judge keeps certain testimony out, prevents certain witnesses from testifying, that could be good grounds for an appeal. Overturning convictions on appeal is very rare.
All right. So the other interesting thing to me in this case is that once sentenced and once serving that time, there was a lot of talk about the family of the victim who said, listen, yes, we think that's a light sentence. 15 years in jail for taking a life really isn't much, but the jury has spoken. So I think that we all have to be reminded to believe in our justice system, and the jury speaks, and that's what it is. What do you think?
I mean, it seems like it's working in cases of police officers over the last few years. It really feels like society and political activism is starting to break through and starting to get results that are more consistent with what the public considers right and wrong.
All right, so we're going to end the day, but stay with us. Aaron Keller with Daily Debrief starts at 5 o'clock.